Hey, good afternoon. Committee on Judiciary and Hawaii Affairs called to order. It's Wednesday, March 30th, 2022, 2:00 p.m. in conference room 325. We have a number of bills on the agenda today. First one is SB 3089, Senate Draft 2, House Draft 1, relating to emergency management. Vice Chair.
Great. All right, first up to testify, we've got Department of Human Services in support.
Good afternoon, Chair Nakashima, Vice Chair, and members of the committee. Amanda Stevens, representing the Department of Human Services. The department stands in support of written testimony and providing comments on this measure. And we truly thank you for this opportunity to testify today. Mahalo.
Okay, thank you. Next up, Department of Defense in support. Department of Defense.
This is David Lopez on behalf of Director Hara for Department of Defense. We stand on our written testimony. We're available for questions. Thank you.
Okay, thank you. Next up, Chamber of Commerce of Hawaii with comments.
Thank you, Chair, Vice Chair, members of the committee. Trevor Abrazo with the Chamber of Commerce Hawaii. We offer comments on Senate Bill 3089. The only thing we had questions about was the seasonal pricing increases and the price gouging language in the bill. Some industries could be affected adversely to this that might not be even involved in the emergency declaration. Prices go up in certain industries, especially here in Hawaii with tourism, and we just wanted to bring that to your attention. Thank you. Happy to answer any questions.
Thank you. Next up, Grassroots Institute of Hawaii with comments.
Aloha, Chair, Vice Chair, and members of the committee. My name is Ted Kafalis. I'm the Director of Strategic Campaigns for the Grassroots Institute. We're very much in favor of this bill, SB 3089, and we feel like it's a very important step towards restoring public trust in government. 35 state legislatures currently have the authority to end an emergency proclamation, according to the NCSL, and we hope that Hawaii will become number 36. We especially appreciate the provision to address the suspension of public records requests during the emergency. But with that being said, we do feel that this bill could have a little bit more teeth if it required legislative approval for the governor to issue any supplemental emergency proclamations. There are 10 other states that have taken this approach and require their governor to seek legislative approval for any additional emergency proclamations. So if the committee elects to take this approach, we've provided some proposed amendments in our written testimony. Mahalo for your time and consideration.
Thank you. Is there anyone else here to testify on this measure? If not, members, any questions?
Chair.
Yep, report.
The Grassroots Institute, when you said what the other states have done, is it actually an extension of an emergency proclamation when you said in the plural, or was it where the other related emergency proclamations?
So 35 other states have the ability to terminate a proclamation, but 10 of those states have introduced a provision where the governor needs to have legislative approval before extending or issuing a supplemental emergency proclamation.
So for extending it, the governor has to get permission to do that.
Correct. Whether that's in session or out of session, they would.
Does this bill do that?
This bill does not right now. This bill allows for a 2/3 majority to stop a governor's emergency proclamation, but he can continue to issue an emergency proclamation without getting that legislative approval.
And you think it should have that condition in the bill? Yes,
correct. And we've included some proposed amendment language in our written testimony.
Terrific. Thank you for your testimony. Thank you,
Thank
Chair.
you.
Members, any other questions? Okay, hearing none, let's move on to SB 3087 SD1 HD1 relating to the Emergency Management Assistance Compact. Got one testifier here today, Department of Defense in support.
Yes, good afternoon, Chair, Vice Chair. This is David Lopez, Executive Officer of HIEMA on behalf of Director Hara, Department of Defense. We stand on our written testimony in support of this. We're available for any questions. Thank you.
Thank you. Anyone else here to testify on this measure? Seeing none, members, any questions? All right, let's move on to SB 2777 SD1 HD1 relating to search of female inmates. First up, we have the Department of Public Safety in opposition.
Good afternoon, Chair Mari Nakashima and Vice Chair Mariyoshi and members of the committee. I'm Tommy Johnson, the Deputy Director of Corrections. The Director, Maxatani, apologized he couldn't be here today. We'll stand our written testimony in opposition to this measure, but we would like to point out that we do have a correctional policy 0.0831 that deals with search of inmates, and we follow federal PREA guidelines when it comes to searching of inmates. And I'm available for questions if you have any.
Good, thank you. Next up, we've got Community Alliance on Prisons in support. Ms. Brady, are you there? I can see her. She's muted either. Is she not muted? No mic. Okay, we're going to come back to Community Alliance on Prisons. Hopefully they can get their mic working. Next up, we have Women's Prison Project in support.
Whoa. Yes, thank you. I'm Linda Rich, testifying on behalf of the Women's Prison Project. We consider this a very important bill, and while we are in support of the bill, we also want to ask for some amendments to it. First of all, let me just read a little bit of my written testimony. Women's Prison Project understands that this bill covers areas that the Federal Prevention of Rape Elimination, PREA, law also covers. We acknowledge that the Department of Public Safety Administration takes PREA seriously and diligently mandates PREA training for correctional officers and volunteers. That said, it is still the difficult reality that the searching of women inmates by male corrections officers is traumatizing and has been found to violate women's Eighth Amendment rights. That is what this bill is really about. DPS has been complying with PREA, but vulnerable women are still being traumatized when male ACOs perform hand-on searches of their bodies, touching their breasts, thighs, and crotch area. In 2020, the United States Commission on Civil Rights issued a report titled Women in Prison, Seeking Justice Behind Bars. The commission found that many prison policies and facilities are not designed for women or tailored for their specific needs. They went on to say, quote, incarcerated women report extremely high rates and much higher rates than men of histories of physical, sexual, and mental trauma. Notwithstanding federal statutory legal protections such as PREA aimed at protecting incarcerated people, many incarcerated women continue to experience physical and psychological safety harms while incarcerated and insufficient satisfaction of their constitutional rights. The commission offered this specific recommendation. PREA standards require prison officials to hire sufficient staff to ensure the safety of incarcerated persons, including sufficient women staffing to perform searches and supervision in sensitive areas. In order to implement these requirements and comply with Title VII of the Civil Rights Act of 1964, officials should consider a rigorous analysis of their hiring practices, including whether a bona fide occupational qualification is appropriate for any posting.
Linda, it's been over 2 minutes. Can you summarize and conclude your testimony, please?
Yes, I will. Permitting male prison guards to touch women's breasts and crotches of female prisoners in the context of routine pat-down frisks violates their Eighth Amendment rights, their right against cruel and unusual punishment. And we would like to ask to have the 3 amendments that were deleted after the last hearing returned to this bill. They require DPS to increase its recruitment and training of female adult corrections officers, require the DPS to address the concerns of advocates, the requirements of PREA, and staffing shortages of female gender-specific posts, and require a report to the legislature. And we ask that that be reinserted back into the bill. Thank you.
Okay, thank you. And I just want to remind testifiers that we do have a 2-minute time limit to try to keep, or out of respect for the other testifiers as well. All right, is Kat ready on again? Okay, let's go on to ACLU of Hawaii in support.
Aloha Chair, Vice Chair, members of the committee, Carrie Ann Shirota on behalf of the ACLU of Hawaii, we also support this measure. We would like to point out that this is a harm reduction measure. This is a step towards reducing harm against women by prohibiting pat searches by male staff and limiting placements of male staff when women are undressing. We also want to acknowledge the fact, though, that PREA is a standard, it's the lay of the land, it's federal standard, but that the state can pass laws that provide a higher level of protection. Linda just made reference to the 8th Amendment. We can also look at privacy interests. There are still some privacy interests, even if someone is incarcerated. And then depending on the searches path on, if it moves on to a more invasive search, that gets into 4th Amendment search and seizure, illegal. I just want to read a quote from Amy Fettig, who is the Deputy Director of the National Prison Project. Women's experience of prison as a place of abuse, violence, psychological deprivation, and physical harm is both a human rights tragedy and an indictment of our criminal, legal, and correction system. Although many aspects of prison life produce tangible harm to women prisoners, their families, and ultimately the community, the crisis proportions of sexual violence behind bars demands our immediate attention. The lives of women who are incarcerated can no longer be ignored and discounted where their civil and human rights are violated. We can and we must end sexual violence behind bars. This measure will move us closer towards doing that. And we have to also remember the best strategy to eliminate sexual harm and violence in our jails and prisons is to decarcerate and have women who can receive services in the community rather than incarceration. Thank you for the opportunity to testify in support of this measure.
Thank you. Last call for Community Alliance on Prisons. Okay, is there anyone else here to testify on this measure? If not, members, any questions? Yep, report.
Thank you, Chair. Public safety, are you still there?
Yes, I am, Representative.
Given that you were, sorry, I haven't got your testimony, but given that you said you were against the bill, that means you guys are now doing patting down of women by men and you want to continue doing that? Question mark?
No, I think the issue here is that we have a couple of twofold. One, we have been increasing our recruiting efforts for females in the prisons, in the jails, and we're running day and night classes. Second thing is the males are not allowed, male corrections officers are not allowed to do pat down searches of female routinely unless it's an emergency. And if it's more invasive search, as Carrie Ann Shirota mentioned, then it will be done by a female corrections officer. Males also are not allowed in the shower areas where females are going to be in any kind of state of undress. And males also must announce themselves when they're going on any type of housing unit for females, so the females will know that the male is on the floor. It's the same way if a female ACO goes to a male housing area, she has to announce herself as well.
So you're saying you're not doing it, haven't done it, and you're not going to do it. And if it's on the books, what's the harm?
What I'm saying is that our correctional policies specifically address the issue of male or corrections officers doing pat searches or any type of searches of the opposite sex, and that policy goes far beyond what's in the federal standard of PREA, and that we don't believe that this measure is needed because it may hamper our ability to provide a safe environment for the inmates.
How would it hamper the safe environment?
We may not be able to do a pat down search if we can't get a female immediately and someone's life is in danger, or if there's a security situation. The male staff may have to enter into a female housing area once they announce themselves. The females have to get dressed right away. You have to understand, and I hope all do, is that in a correctional setting, we're running 24/7. We can't always have, even though we have female designated posts, if the females don't show up, call in sick, we try to fill that post with a female. If we can't, we have to fill the post with a male. But we always try to have a female on post. And again, the males do not enter the housing units or restrooms or dorms without announcing themselves. And they don't announce themselves after they're in there, announce themselves before they go in.
Using TSA as an example, the pat down is when the technology fails. So have you guys got technology that also in the middle of the night, you don't have to do a pat down, or you don't have technology, therefore you only use pat down?
We have technology at the entrance to the facility, but it would be too expensive to have that type of technology in each of the housing areas.
I'm sorry, I didn't hear that very.
I'm sorry. We have the technology.
The audio is a little bit weak.
Let me see if I can turn it up. Is that
So you
better?
have technology.
Yes, we have technology.
Oh,
but we
that's
have
better.
Technology to the entrance of the facilities, not inside the facilities in the housing units.
Which if you used, would that eliminate patting down?
If we did, but it's not cost effective. You're looking at spending hundreds of thousands of dollars to put a single machine in every housing unit where there's a female or male staff that are housed, and you require them to go through that every time they enter or come out of the door.
Okay, got it. Thank you very much. Thank you, Chair.
Members, any other questions on this measure? Seeing none, let's move on to SB 2091 SD1 HD1 relating to executive pardons. First up, we've got the Department of Public Safety with comments.
Good afternoon, Chair, Vice Chair, members of the committee. I'm Tommy Johnson, the Deputy of Corrections. Again, Max Otani couldn't be here today. His apologies. We submitted just comments. We'd ask you to please look at the comments because we have been involved in the pardons process for years, and we see this this measure as adding additional layers to the pardons process that doesn't really need to be there. Thank you.
Okay, thank you. Next up, we have the Hawaii Paroling Authority in opposition.
Hello, and good afternoon, Chair Nakashima, Vice Chair Matayoshi. My name is Fred Hyun, Chair of the Hawaii Paroling Authority, and I stand on my written testimony, but offer some historical, factual insights and information that illustrate my concerns and context regarding and relating to Senate Bill 2091 SD1 HD1. Few people know who was the first person to be paroled and receive a pardon in Hawaii. Her name was Lydia Kamakaeha. She was originally sentenced to 5 years of hard labor and fined $5,000 in 1895. On September 4th, her sentence was commuted and she was imprisoned for 8 months in a single room on the second floor of the executive building, then placed under house arrest for 5 months at her earlier home that her husband built. What was communicated to her by a government official, and in her own words, I was supposed to be under parole and could have been arrested and recommitted at any moment. On October 13th, 1896, Lydia was pardoned by Sanford Dole, restoring her civil rights that allowed her to travel to Washington, D.C. to seek help for the restoration of the Hawaiian Kingdom. Yes, this was Queen Liliuokalani. And from her imprisonment and pardon came her greatest works. Flash forward to 2022. All should be aware that a pardon granted today is not an expungement of criminal convictions, but based on rehabilitation and exemplary behavior within the community over an extended period of time. Pardon does not erase an offense for which a person was convicted for. A pardon is not amnesty, and it is not clemency. It is about forgiveness by a governor for a crime committed. It is about no further punishment for the forgiven offense and should not be penalized for having a record of the offense. In closing, Robert Wilcox, leader of the insurrection, was convicted and sentenced to death, and then later pardoned by Sanford Dole on April 8, 1898, released and restored his civil rights, ultimately to become a congressional delegate and politician. Thank you for the opportunity to speak, and I am available for questions. Thank you.
Thank you. Next up, Honolulu Prosecutors in support.
Good afternoon, Chair Nakashima and Vice Chair Matayoshi and members of the Judiciary and Hawaiian Fine Affairs Committee. You have our testimony in strong support of this measure. I just wanted to make a few comments to provide some context, and I'm not going to go back quite as far as Chair Huon did, but I began testifying on victim rights measures in 1977 before the legislature, and at that time, victims didn't have any rights. Over the years, with the wisdom and support of the legislature, victims now are involved in participating and transparency throughout the criminal justice process. This is basically unfinished business. All that this measure does, it says that victims and their surviving family members and prosecutors have the opportunity to be aware that a pardon is being considered and to offer comments about that potential pardon. It's as simple as that. We have gotten victims involved in every other step of the process. They're allowed to testify at sentencing, to parole minimum hearings. In fact, in 1996, when they were allowed to attend the parole minimum hearings and make a comment, that was initiated by the paroling authority. They were the ones who said, this cannot be a policy. This has to be something that's in the statute to ensure that in the future, every victim will be able to participate. I ask your support for this because I think that this is actually a simple measure. It ensures that everyone has a right to participate. Everyone knows what's going on. And it really, I think, provides for confidence, not only by the public as a whole, but to victims and prosecutors and other people who are part of the system, that this is something that is on the up and up, and all due consideration has been given before a pardon is actually granted. Thank you.
Thank you. Next up, ACLU of Hawaii in opposition.
Aloha Chair, Vice Chair, members of the committee, Carrie-Ann Chirota on behalf of the ACLU of Hawaii. We also oppose this measure. We like to start off sort of again with the big picture that's already been shared. What is the purpose of pardon? Pardon is essentially saying that people should be given second chances. As Brian Stevenson has said, that people are not the worst thing that they've ever done. And if you look at the process itself, this is not, pardon doesn't occur just by happenstance. There is a process to go through, and this occurs after a person has completed their sentence. Again, I want to emphasize completed their sentence. The ACLU is very mindful of the fact that victim survivors are impacted and may have lifelong impacts on them. But we also believe that there is a place for prosecutors as well as victim survivors to participate in the process. They can have sometimes sway influence over the charge in terms of sentencing with the courts, also within the paroling process for minimum sentence as well as parole decisions. But this is an area where we should focus again on, has this person shown through a period of time that they are deserving of second chances? As Chair Huon pointed, this is not an expunged. It still stays on a person's record. And as we know, there are collateral consequences for having a conviction unless someone has the ability to expunge, which is not the case here. And we want to emphasize the fact that it is really important that for all of those that we talk about victims and survivors' rights, that we provide victim survivors with opportunities for restorative justice. Our system does not really include that in our system as other jurisdictions have done. So if we really want to give victim survivors more opportunities to have more say in terms of the harm restoration, let's invest in those types of services and programming. And I want to just add on a personal note that I am a person who I consider myself, I've been victimized in the past. I'm a survivor of violence individually. And I also, as a 6-year-old child, my uncle, my mom's brother was murdered on the island of Maui. And so I do not mean to come across as being disrespectful of victims, but I think there needs to be more emphasis on opportunities for healing and restoration. And there has been a place for victim survivors and prosecutors, and that's at other parts of the system. But when it comes to a pardon, again, the focus is different, and we ask that you defer this measure. Thank you very much for the opportunity to testify.
Okay, thank you. Next up, we have the HPH Sex Abuse Treatment Center of Hawaii in support.
Good afternoon, Chair Nakashima and Vice Chair Matayoshi. My name is Lynn Costales, and I'm with the Sex Abuse Treatment Center. Thank you for the opportunity to provide testimony on this very important bill. On behalf of sexual assault survivors, we are in support of this bill. I would like to note that The comments that are being provided thus far are very well intended, and we certainly appreciate all of that that is being said in opposition and in support of this bill. I think when it comes down to healing and restoration for victims of sexual violence or survivors of sexual violence, that starts with transparency and trust. And I think this measure is an opportunity to build that trust and provide that opportunity for victims to at least have some transparency as to what is going on within the system, and just to allow them to have a voice to be heard. Again, healing starts with trust, and I think that's what this bill is trying to do on behalf of survivors and victims, and we stand in support of it. Thank you very much.
Yeah, thank you. We have four individuals writing in support, one in opposition. The one in opposition should be on Zoom. Peter Collier, George, are you there?
Yes, Cooley George, thank you for allowing me to testify. My remarks are brief. I think that kind of at the bottom line, prosecutors don't necessarily have a role to play in this process. I think the prosecutors are already thoroughly involved in the criminal legal system, and that pardons are more about forgiveness and moving on for rare cases, because they are not frequently used, but for individuals who have shown that they deserve the chance to return to the community through either behaviors that they have kind of been seen for, or whether we believe that maybe there was some sort of mistrial or errors within the system where someone who is a really great member of our community should be returned to it. And I don't necessarily think that we should be including more barriers to this process. And I think that this is rather unnecessary, especially considering how rare pardons are. So thank you for allowing me to speak.
Thank you. Is there anyone else here to testify on this measure? If not, members, any questions?
Chair.
Rep. Ward.
And I forgot the gentleman's name. Who was here in 1977? Who is the best looking dog in the building? Okay.
Only person in person.
Okay. How does this compare to what's going on in the mainland? Are we just catching up with them, or are we leading
Many
the
other
pack?
states have similar provisions that allow victims and prosecutors to be part of the process and to be informed.
Does it work?
Seems to.
Do
I
they
know that
participate?
victims advocates that I've talked to say it gives the victim a feeling of, again, fully participating in the process. It's interesting because a lot of the people that I've talked to have said that on many occasions, some of the victims are saying they're in favor of the pardon, not necessarily against it. When time has passed, victims want to move on sometimes, and they're not necessarily speaking against the pardon.
That's a good point. Have pardons ever been overturned because of these things being on the books in those states that have it?
No, because similar to here, this doesn't affect the governor's authority to grant a pardon in any way. This doesn't limit or overturn or anything else. It just simply says prosecutors and victims have a right to know about the process and have a right to participate by offering comments, and that's it.
Let me rephrase the question. How many pardons have been overturned, regardless of what state or what things are on the books?
I'm not aware of any.
Okay, that's good to know. Okay, thank you. Thank you, Chair.
Any other questions, members? If not, let's move on to SB 2305 relating to the Comprehensive Offender Reentry System. First up, Department of Public Safety in support.
Yeah. Good afternoon, Chair and Vice Chair, members of the committee. We are in support of this measure. It really just corrects a typo in the language in the statute. Thank you very much.
Thank you. And we have a number of individuals testifying, submitting written testimony in support. One is here, Peter Collier, George, in support. And you're muted.
Thank you. Yes. Again, very brief remarks. I just want to support this measure to provide that kind of clarification that we're looking for the timely release of inmates at their minimum sentence rather than maximum.
Thank you. Anyone else here to testify today on this measure? Seeing none, members, any questions? All right, let's move on to SB 2279 ST2 HD1 relating to catalytic converters. First up, AG's office with comments.
Good afternoon, Chair Nakashima and Vice Chair Matayoshi. Lance Goto for the Department of the Attorney General. The department supports this bill, but has comments and concerns about one provision which was added to the House Draft 1 after the last hearing. And this is on page 7 of the bill, lines 3 to 9. It's a provision that creates an exception to the documentation requirements for used auto parts dealers engaged in transactions involving catalytic converters. When the dealer is also a licensed scrap dealer and purchases the catalytic converter from another scrap dealer, a motor vehicle repair dealer, a mechanic, or a towing company. And our concern is that by creating this exception to the documentation requirements, we're not going to be able to document that transaction. And so it's possible that a person who stole a catalytic converter could sell it to one of these named commercial vendors and who do not have the same documentation requirements as under Chapter 289, and then turn around and sell it to this licensed used auto parts dealer who also happens to have a scrap dealer license, and the exception would apply. And again, there would be no documentation. So it's creating a loophole in our law, which may be a problem. Thank you.
Okay, thank you. Next up, we have the Department of Transportation and Support.
Yes, Vice Chair Matayoshi, Chair Nakashima, members of the committee. The DOT is in support of the measure and we'd like to stand on our written testimony, but we do have a tendency to agree with the Attorney General's office. Thank you very much.
Okay, thank you. Next up, HPD and Support.
Good afternoon, Chair Nakashima and committee members. I'm Brandon Yamamoto, Captain with the Honolulu Police Department, District 5. The HPD stands by its written testimony in support of this bill, as we feel it will strongly discourage the theft of catalytic converters by making it more difficult to sell outside of any legitimate purpose and practices. And it will make it easier to identify individuals who do sell these items. By also making it a felony, it would further discourage the would-be criminals from attempting thefts of these items. Thank you.
Okay, thank you. Next up, Honolulu Prosecutors in Support with proposed amendments.
Good afternoon, Chair, Vice Chair, members of the committee, Deputy Prosecutor Tricia Nakamatsu on behalf of the Honolulu Prosecuting Attorney's Department. We are in support of the bill. Overall, we're in strong support and we hope you'll pass something. We do have serious concerns though, however, about the same exemption mentioned by the AGs. That's on page 7, lines 3 through 9. To begin with, we think that anyone who deals in used motor vehicle parts, like catalytic converters, should get a used motor vehicle dealer's license. It just goes with the definition of the territory. To create a giant exemption just for certain types of scrap dealers, certain types of non-used motor vehicle parts dealers seems unnecessary and potentially confusing, leading to, again, a possible loophole. We will note that in speaking with the licensing division, the only base requirement to get a scrap dealer's license is to have a GE tax license. And that is pretty much it. So we feel that it's a very low, too low standard. So all of the parts really regarding scrap dealers should be taken out of this proposed amendment. With regards to, we do feel, again, they should have a used motor vehicle parts license, which we know only costs $10 a year, has a slightly higher threshold. The applicant has to go through a criminal background check and submit some notarized documents. That said, the people that they sell to, then the auto repair dealers has a pretty stringent licensing process. They actually have to get their application approved by a board. And then there's also confirmation that the applicant has sufficient facilities and equipment to actually do the work. The second one, we'll note on the last 2 lines of our proposed amendment, would allow the used motor vehicle parts dealer to buy catalytic converters from wrecking, salvaging, or dismantling people with that type of license. Essentially, it's still going to be tow companies who take the entire car and then break it down to try to sell the parts. We feel it should also have that same used motor vehicle parts license, and we would defer to the committee whether they feel that is a high enough standard. They too just need a criminal background check and a couple of notarized documents. Available for questions, if any.
Okay, thank you. Last up, we have Mr. Steele, Hawaii, with comments.
Aloha, my name is Melissa Pavlicek. I'm here today on behalf of Schnitzer Steel. We do support legislation to improve the situation with catalytic converter theft and absolutely want to minimize metal theft of any kind in Hawaii and are very proud of our training programs and other things we've collaborated on with law enforcement. We offered the exemption that the Attorney General and the prosecutor have said is too broad, and we're definitely looking for ways to narrow the scope of this exemption. But the intention was really for the legitimate business to business transaction to be able to rely on the proper documentation and the evidence of compliance that has been done by the licensed organizations that the prosecutor's office has referenced. So we would ask for your help in crafting a more narrowly tailored exemption rather than removing it entirely. Thank you very much.
Thank you. Is there anyone else here to testify on this measure? Seeing none, members, any questions? Report.
The AG, please. Are you still there?
Lance, are you still there?
Yes.
Your suggestions about the loophole, that seems very well taken. Should we do a shopping list of all those that you mentioned, scrap dealers, tow trucks, or what's the remedial example or let's say solution?
Well, the solution is just to remove that exception. Let's create an exception to the documentation requirements for those types of dealers. And so our recommendation is to just remove it and leave it with the used auto parts dealers having that documentation requirement.
Would you happen to have any metrics between the number of stolen in 2020 versus 2021? The HPD said it's going up, but do you actually have any metrics?
Sorry, I do not.
You may not know this one either then. What's the going price for a catalytic converter? What's the street value? Oh, we don't know that either. Okay, we should know that. But otherwise, it sounds like this is getting out of hand. And if we don't do something, it's going to be a bigger problem than it already is. Thank you. Thank you, Chair.
Members, any other questions? Now let's move on. SB 1211 ST2 HD1 relating to motor carriers. First up, we've got Department of Transportation in support.
Vice Chair Matayoshi, Chair Nakashima, members of the committee, the DOT is in strong support of the measure, and in the interest of time, we would like to stand on our written testimony. Thank you, sir.
Okay, thank you. Anyone else here to testify on this measure? Seeing none, members, any questions? All right, let's move on to SB 3140 SD1 HD1 relating to the Uniform Controlled Substances Act mandatory reporting. We've got one testifier here today, Department of Public Safety in support.
Good afternoon, Vice Chair, Chair, members of the committee, Jared Radula, the State Narcotics Enforcement Administrator. The department is in strong support of this measure. We will stand on our testimony, and I just want to note that this is a very important measure for us because it allows us to receive timely reporting when there's a problem with someone's inventory. And with timely reporting comes increased ability to solve these cases. So thank you very much.
Thank you. Anyone else here to testify on this measure? If not, members, any questions? Okay, we're moving on. SB 3141 SD1 HD1 relating to the Uniform Controlled Substances Act. First up, we've got Department of Public Safety in support.
So again, Jared Radula with the Narcotics Enforcement Division. This is our annual recommendation as required by statute to make our laws consistent with federal changes. Last year, the federal government did in fact schedule many different new controlled substances, and this measure is reflective of those changes. We'll stand on our written testimony and support. Thank you.
Okay, thank you. Anyone else here to testify on this measure? Seeing none, members, any questions? All right, let's move on to SB 2032 SD2 HD1 relating to genetic information privacy. First up, we've got DCCA Office of Consumer Protection in support.
Good afternoon, Chair, Vice Chair, members of the committee. Raji Tolentino standing in for Steve Levins. The Department of Commerce and Consumer Affairs stands on its written testimony support. Thank you.
Okay, thank you. Next up, we've got the Coalition for Genetic Data Protection in opposition. Okay, just in the future, speaking to the microphone so that the Zoom guys can hear you too, but he's standing on his written testimony in support other than the private right of action section. I'm sorry, in opposition, other than the really opposing the private right of action section. Is that fair? Okay, anyone else here to testify on this measure? Members, any questions? Yep, Rep. Ward.
The gentleman who didn't hear what he said. Did you say you represented the genetic testing industry?
It's a
Oh, okay, good.
coalition, yes.
What is the practice now that a bill here says, hey, guys, you shouldn't be using this for anything other than what we do for ancestry.com, et cetera? Is this kind of a law in prevention of you doing something, or are you doing something that this bill says you should stop doing with this genetic information?
Yeah, I think the bill was intended to create privacy protections by the way of requiring consent or express consent on the part of the consumer with respect to the use and disclosure of the information. So that's the gist of the bill.
So are any of the genetic ancestry or other people using it for untoward purposes now? So we're preventing something that hasn't happened, but it should be already in the privacy.
I'm not sure I understand your question. I'm sorry.
No, are there any untoward things being done with, for example, I went through ancestry.com, I went through genetic something. Are some of those people like selling it or doing anything with it untoward?
Not to my knowledge.
And so this bill just does something that says, don't even think about doing anything with our blood.
Essentially what this bill says is that if this information is going to be provided, that certain uses of the information or disclosures have to be done only with the consent of the consumer. So that's the protection that's afforded by this bill. It's a privacy bill.
It seemed to make sense. It would seem like when you sign up for these companies, that would be part of the agreement that you check and say you agree with. Thank you very much. Thank you, Chair.
Thank you.
Okay, any other questions, members? Okay, seeing none, we'll move on to SB 2137 SD2 HD1 relating to transitional housing. First up, we've got the State Department of Health in support. No one? Okay. I guess we've got nobody. Anyone else here to testify on this measure? All right, seeing none, we'll move on to SB 3223 SD1 HD1 relating to public works. First up, we've got Department of Labor and Industrial Relations in support.
Good afternoon, Chair Nakashima, Vice Chair Matayoshi, and members of the House Committee. Joanne Videnhar, Deputy for the Department of Labor. We are standing on our written testimony and support and here for available for any questions. Thank you.
Okay, thank you. Next up, we have General Contractors Association of Hawaii in opposition.
Aloha, Chair Nakashima, Vice Chair Matayoshi, members of the committee. The GCA stands in opposition to the measure as currently drafted. GCA understands the issue that the bill aims to address, which is a firm who has been barred from bidding on a public works project for 3 years due to the 3-strike rule could have its officers start a new company and bid on projects. GCA is open and willing to find language that closes this loophole. We agree with the stakeholders in the concept proposed. However, as currently written, this measure has many unintended consequences and would create more issues than it attempts to address. The potential unintended consequences are complex and need to be addressed to prevent us from taking 1 step forward and 2 or 3 steps back. First, the measure says that the firm and RME shall be subject to the fines for the offenses. However, the measure fails to take into account that there is often multiple RMEs at each firm. For example, the first company I contacted about this issue told me they have 5 RMEs at their firm. Do all 5 RMEs receive notices of violations and each are subjected to pay back the wages? And in the case of a third offense, each pay double the back wages? Do all of the RMEs get suspended? The bill doesn't address this. An RME is someone licensed as an RME as a general contractor for the firm. They actually have zero oversight of the payroll. In some cases, the firms outsource their HR and payroll to third parties such as Ultras. However, assuming that if some individual and not the firm needs to be pinned for the violation and the RME is the one, the current language of the bill could also subject an RME to 3 violations for 1 offense. That's because subsection D of 104-24 says that a violation refers to each project in which the department finds that a contractor has failed to comply with the chapter. So what happens if you have a wage violation for a specific laborer for 1 day, but during that day, that laborer worked at 3 different projects? Could that mean that you're subjected to 3 violations for the same offense? Also, an individual may be an RME for more than 1 contracting entity. A company unrelated to the projects at issue could potentially be banned from bidding on public works projects. So again, we are not opposed to preventing bad actors from gaming the system and creating companies to get around the 3-strike rule. We are more than happy to work with the stakeholders to see if there's a way we can craft language to close this loophole without creating a new set of problems. In order to address these issues, we ask that the committee defer decision-making to a later time to allow the stakeholders to meet and attempt to address these issues. Thanks.
Yeah, anyone else here to testify on this measure? If not, members, any questions? All right, seeing none, let's move on to SB 3251, ST1 HD2 relating to hunting guides. First up, we have the DLNR in support.
Yes, hi, my name is Jason Omick. Thank you, Chair, Vice Chair. Yeah, we stand by our written testimony in support with comments. I just wanted to add one thing to this. You know, this bill was initially drafted for hunting guides only, and now with the amendments, it's directed to all hunters that may want to hunt on private land. For those hunting guides that want to get a permit from the state to guide on private property, at that time we can ask for a permission slip, and so that seems doable. But for other folks, the other 13,000 hunters that may come here and hunt on private lands, they get their license electronically, and it may be hard for us to monitor whether they have a permission slip or not. And so yeah, those are my comments. The bill was initially drafted for hunting guides, and it seems like it's now being made for all people hunting on private lands to get permission from the landowner and furnish that to the department. Thank you for your time.
Okay, thank you. Anyone else here to testify on this measure? Okay, seeing none, members, any questions? All right, let's move on. SB 166 SD1, last bill on the agenda relating to campaign finance. First up, we have the Campaign Spending Commission with comments.
Good afternoon, Chair, Vice Chair, members of the committee. My name is Gary Kam, and I'm with the Campaign Spending Commission. The commission appreciates the intent of this bill and has submitted comments in writing. I would like to emphasize, though, that we ask this committee to make this bill effective for the 2024 elections. That will give the commission time to make modifications, make whatever modifications are needed to the electronic filing system, as well as educate existing committees and corporations that may want to participate in the election. Thank you.
Okay, thank you. Next up, Common Cause Hawaii with comments.
Good afternoon, Chair, Vice Chair, and members of the committee. Sandy Ma for Common Cause Hawaii. We submitted comments on SB 166. We appreciate the intent of this bill. We think SB 166 SD1 is an excellent start to protecting our elections from foreign interference. We do feel that there could be some further refinements made to this bill. For example, there should be more definition provided as to the foreign ownership thresholds. Suggestions have been made by other testifiers in their written testimony submitted to this committee, and we suggest reviewing those foreign ownership thresholds for some guidance. We also are concerned that this bill only talks about corporations and not nonprofit corporations. Common Cause Hawaii has been firm that all corporations, nonprofits included, should be covered. And also we are concerned about the certification provision. The certification provision provides on page 6 that the corporation's chief executive officer must sign under penalty of perjury. Some corporations are quite large, and it may be hard to have the chief executive officer sign within 7 days of making any such donation. And so we just wanted to highlight some of the provisions of this bill that could use further refinement. Thank you for allowing Common Cause Hawaii to testify with comments on this bill, and I'm available to answer any questions. Thank you.
Thank you. And last up, we've got Free Speech for People in support.
Thank you. My name is John Bonifaz. I'm the president of Free Speech for People and a constitutional attorney. Thank you, Chair, Vice Chair, and members of the committee for allowing me to testify. I stand on the written testimony we have submitted, but add these additional comments. We are in qualified support of this bill, conditioned on one critical amendment. Just by way of background, we are a national nonprofit organization dedicated to defending our democracy and our Constitution. And we have helped to develop legislation to end foreign corporate spending around the country. There is a law that's passed by the Seattle City Council in January of 2020, which we helped to develop, as well as a measure just approved last week by the San Jose City Council in California. This bill similarly is pending in the New York State Senate with bipartisan support. It's passed there and is now pending in the New York State Assembly. And it's recently been introduced into the U.S. House of Representatives by Congressman Jamie Raskin of Maryland with a number of other original co-sponsors. We have proposed to advance this legislation in a number of other states and are working in partnership with the Center for American Progress on this matter. With one change, we would be pleased to endorse the bill. It comports with U.S. Supreme Court precedent, including Citizens United and Blumen v. FEC, to protect democratic self-government. And it has no impact on individual immigrants or on businesses owned by green card holders. However, the definition of foreign influenced corporation, we recommend splitting that into two definitions and reinserting the following language from the original draft of SB 166 to expand that definition. First, a single foreign owner under our proposed amendment, which was in the original draft of SB 166, a single foreign owner that holds 1% or more of the total equity, outstanding voting shares, or other applicable ownership interests of a corporation would define a foreign influence corporation, or only in the alternative, 2 or more foreign owners having 5% in the aggregate of ownership of the corporation. The reason that these thresholds are important is that a single stock owner of a major Fortune 500 company can get the CEO on the phone, can propose a shareholder resolution, has significant influence over a corporation. And among others, Harvard Law professor John Coates, a nationally recognized corporate law expert, has identified that that is where an individual or an entity can hold significant influence of a corporation. And certainly the 5% in the aggregate comes from SEC law. We have submitted testimony in writing in support of these thresholds, and we would urge the committee to amend this bill to have those thresholds in place and to ensure that 98% of the S&P 500, which hold significant foreign investment under such thresholds, would be covered by this law. Thank you.
Okay, thank you. Anyone else here to testify on this measure? Okay, seeing none, members, any questions? Yep, Rep. Ward.
Chair, to the present testifier, do we have an example of a name, a company that makes this thing go from abstract to real? What's a foreign influence corporation you can name that has been involved in these kind of things and this bill attempts to prevent them from doing it again?
Yes. Amazon is an example of a company. They spent $1.5 million in the Seattle City Council race in November 2019. And as a result, the Seattle City Council passed this law unanimously to ensure that such a foreign influence corporation would not be able to spend such funds from their general treasury funds going forward. You may remember that President Obama, after the Citizens United ruling, criticized the ruling because he said it would lead to foreign influence in our elections. And that is, in fact, what's happened. Foreign investors can now use the corporate form to subvert existing federal law that bars foreign nationals from having any role in spending money in our elections. And they can do so through their shares in companies, multinational actors that want to spend money in our elections.
So what's the ownership structure of Amazon?
Well, Amazon has a more than 5% ownership in the aggregate of foreign investors. I think it's at 7 or 8% right now.
And that's the threshold to say foreign influence, 5 to 7%.
Well, no, the threshold that is in that law that's been passed by Seattle and what we're proposing be amended for this law would be either 5% in the aggregate of foreign investors or more, 5% or more, or 1% a single stock owner. And a single stock owner of a Fortune 500 company, of course, owns hundreds of millions of dollars of shares in that company and is quite influential.
Would Tesla fit this category of foreign?
I have not looked specifically at Tesla. We certainly could go back and look if that's of interest. But as I said, 98% of the S&P 500 have significant foreign ownership and would all be prohibited from making expenditures, political expenditures under this kind of bill.
Did you say 98%?
98% of the S&P 500 all have foreign investment at significant levels with these thresholds.
Okay, thank you very much.
Members, any other questions? Okay, seeing none, we will recess for decision making.
Vice Chair in Hawaiian Affairs for decision making. March 30, 2022, conference room 325. Hey, members, a number of bills for decision making today. Senate Bill 3089, Senate Draft 2, House Draft 1 relating to emergency management. On this, the chair recommends that we delete section 2 regarding the suspension of records requests. Allow that the governor, as situations arise, can reclaim an emergency. So in the case of the COVID, you know, how the virus, it ebbed and flowed and it went up and down and so forth. So if at this point now that the emergency rules are suspended, should something happen, that the governor can reinstate those again. And then also allow for the county councils to override a mayor's executive order by a 2/3 vote.
Mayor's emergency order.
Yes, the mayor's emergency executive order. Technical amendments needed for clarity, consistency, and style. Members, questions or comments? Seeing none, Vice Chair as amended.
The Chair's recommendation is to pass SB 3089, ST2, HD1 with amendments. Chair and Vice Chair both vote aye. Rep. Ishiyama. Rep. Kobayashi is excused. Rep. Lopresti.
Aye.
Rep. Lowen.
Aye.
Rep. McKelvey.
Aye.
Rep. Nakamura.
Aye.
Rep. Takumi.
Aye.
Rep. Tokioka is excused. Rep. Ward.
Aye.
Chair, your recommendation is adopted.
Okay, thank you very much. Senate Bill 3087, Senate Draft 1, House Draft 1 related to Emergency Management Assistance Compact. Chair's recommendation is that we add a preamble providing directions to the revisor statutes on the intended placement of the new chapter on page 5, line 17. Add for the state of Hawaii, legally designated state official / authorized representative shall be the adjutant general. Other technical amendments needed for clarity, consistency, and style. Members, any questions or comments? Seeing none, Vice Chair as amended.
Chair's recommendation is to pass SB 3087, SG1, HD1 with amendments noting the previously excused members. Any members voting with reservations? Any members voting no? Chair, your recommendation is adopted.
Okay, thank you very much. SB 7777, Senate Draft 1, House Draft 1 related to searches of female prisoners. Chair would like to reinsert items deleted from SB 2777, Senate Draft 1. Section 2, where the Department of Public Safety shall increase its recruitment training of female adult correction officers. And Section 3, that no later than 20 days prior to the convening of the regular session, the Department of Public Safety shall submit a report to the legislature regarding its efforts in recruiting, hiring, and training adult correction officers. Members, any questions or comments? Representative Nakamura.
Thank you, Chair, for adding those amendments. I think that we have to recognize the vacancies affect the ability of the department to carry out the legislation. So thank you very much.
Thank you. Members,
Chair.
any other questions or comments?
No, thank you for using common sense. This is what this bill is all about.
Thank you very much. Okay.
Sometimes rare in this bill.
Yes. Okay, thank you very much. Vice Chair as amended.
Chair's recommendation is to pass SB 2777, SD1, HD1 with amendments noting the previously excused members. Any members voting with reservations? Any members voting no? Chair, your recommendation is adopted.
Okay, thank you very much. Regarding SB 2091, SD1, HD1 related to executive pardons, Chair's recommendation is that we move this with amendments that the word reference should be changed in the page 1, line 4 and 8, and page 5, line 10 and 15 to referral. So instead of reference, it should be referral. That on page 2, line 10 to 12, investigation may commence after applicant submits relevant documents to the HPA, which relevant documents are sufficient for these investigations should be a determination of the agency. Technical amendments needed for clarity, consistency, and style. Members, any questions or comments? Seeing none, Vice Chair as amended.
Chair's recommendation is to pass SB 2091, SD1, HD1 with amendments noting the previous excused members. Any members voting with reservations? Any members voting no? Chair, your recommendation is adopted.
Okay, thank you very much. SB 2305 relating to the comprehensive offender reentry system. Chair's recommendation is to move this as is. Members, questions or comments? Seeing none, Vice Chair unamended.
Chair's recommendation is to pass SB 2305 as is, noting the previously excused members. Any members voting no or reservations? Chair, your recommendation is adopted.
Thank you very much. SB 2279, Senate Draft 1, Senate Draft 2, House Draft 1 related to collect converters. Chair's recommendations that we defer this to Monday, April 4, at 2 p.m., room 325. SB 1211, SD2, HD1 related to motor carriers. Chair's recommendations that we move this unamended. Members, any questions or comments? Okay. Members, any other questions or comments? Seeing none, Vice Chair as is.
Chair's recommendation is to pass SB 1211, SD2, HD1 as is, noting the previously excused members. Any members voting no or reservations? Chair, your recommendation is adopted.
Thank you very much. SB 3140, SD1, HD1 relating to Uniform Controlled Substances Mandatory Act mandatory reporting. Chair's recommendations that we pass this unamended. Members, questions or comments? Seeing none, Vice Chair unamended.
Chair's recommendation is pass SB 3140, SD1, HD1 as is, noting the previously excused members. Any members voting with reservations or no? Chair, your recommendation is adopted.
Okay, thank you very much. SB 3141, SD1, HD1 relating to the Uniform Controlled Substances Act. Chair's recommendations to remove this out with technical amendments needed for clarity, consistency, and style. Members, any questions or comments? Seeing none, Vice Chair as amended.
Chair's recommendation is pass SB 3141, SD1, HD1 with amendments noting the previously excused members. Any members voting with reservations or no? Chair, your recommendation is adopted.
Thank you very much. SB 2032, SD2, HD1 related to genetic information privacy. On this one, I'd like to include a savings clause to protect the bill. And that's it. Members, any questions or comments? I'm sorry. You want the private left?
Chair, question.
Yes,
I didn't hear what kind of clause you said you were going to add.
a savings clause,
A which?
a savings clause.
Savings.
Yeah.
Savings. Savings like genetic savings?
It's a, so if the part of the bill gets struck down, then the rest of the bill can carry on.
This is not got and
It's a pretty
replace.
Standard clause.
It's, okay. I said the bad word.
I know. Shame on you.
It's a sever and preserve.
Got and replace.
Okay, members, any other questions or comments? Seeing none, Vice Chair, as amended.
Chair's recommendation is to pass SB 2032 ST2 HD1 with amendments noted previously excused members. Any members voting with reservations or no? Chair, your recommendation is adopted.
Okay, thank you very much. SB 2137 is SD2 HD1 relating to transitional housing. The Chair's recommendation is that we move this as is. Members, any questions or comments? Seeing none, Vice Chair, unamended.
Chair's recommendation is to pass SB 2137 ST2 HD1 as is noted previously excused members. Any members voting no or reservations? Your recommendation is adopted.
Thank you very much. SB 3223 SD1 HD1 related to public works. Chair is cognizant of negotiations ongoing on this measure, and so we'll defer decision making on this until Monday, April 4, 2022 at 2 p.m. in this room, 325. Next, SB 3251 SD1 HD2 relating to hunting guides. It seems apparent that this bill has a shorter title than the authors would like it to have, and so we will defer this measure and try it again next year. And SB 166 relating to campaign finance. The concerns brought up by the last testifier on this measure brings to light some other issues that we need to further consider. And since campaign spending was not going to wanted us to implement this after this coming election, we will defer this measure so we can study it better and come up with a better bill for next year. Okay, with that, we are adjourned. Thank you.